this is about mergers and acquisitions. The one thing I wanted to say at the outset, I want to make this as interactive with you as possible. Obviously, we're going to have a lot of interaction here because that's the better way to do these things, okay, in my experience. Secondly, I know we've been introduced, but the panel that I have here are really experienced practitioners of M&A, okay? And this is very key for the reasons why we are here. We're not going to talk about M&A the way you might think. This is not about reps and warranties and indemnities and the interrelationship of NDAs and letters of intent and purchase agreements. What we wanted to do is have a different perspective and give that to you. Why do we do M&A? Why is it important? How do we structure it? What are the reasons and the fundamentals that go into thinking about doing an M&A deal as opposed to something else? Okay, so that's really the focus here. All right, I think you have some other M&A sessions coming up. So they will probably deal with the nitty-gritty of M&A. We're going to take a more sort of fundamental approach of the underlying principles that go into M&A. So let me just say the reason why we have this panel here is because we have General Counsels and very senior people from a multinational company that came into India, a multinational company that's going out of India. We have somebody from a PE background. We have somebody from a single PE family office kind of background. We have somebody from, but one of the persons we must have is one of our best reputed commercial and corporate and M&A lawyers here. So we're going to give you a perspective from each of these different backgrounds as to why these things that we so fancifully call M&A is done. Okay, it's pretty simple. It's buying a shirt. Does it have 6 buttons? Does it have a collar or not? Okay. So let me, with that introduction, go right into it. The first thing that I did want to talk about is we think in terms of growth for every single corporate entity or sole proprietorship, partnership, whatever. But why do we do that? Why do we not just grow organically? Why do we have to think about inorganic growth? Okay, there are several factors that go into inorganic growth, and I'm just going to throw it out to all our panelists here. We think about synergy. We think about protection of technology. We think about operational expertise that we have or that the target may have. Let me just kind of go into that and ask Sonali and ask PK here as to why and what are some of those issues.
Thank you, Jay. Good morning, ladies and gentlemen. So I come from Tata Steel, and of course, in the last about 5 years, we've done some large acquisitions, starting from the Bhushan Steel, which came to us through the IBC process. So that's a very different kind of acquisition. We also kind of acquired the business of steel business of Usha Martin. Again, a very different process. It's a business transfer. We also participated in the divestment process of Government of India when it came to Neelachal Ispat Nigam Limited, one of the PSUs. So that was a very different process. And of course, we also had one asset purchase. So in the last about 4 years, we've actually had about 60,000 crores of transactions. And added to that, we also kind of had 9 schemes. 8 schemes are currently underway. One scheme, which is merger of Bhushan into Tata Steel, was sanctioned in 2021. So there's been a lot of activity in Tata Steel, at least on the M&A space. Now, why do we get into this kind of space? Obviously, one key driver is the go-to-market, the time that it takes for you to go to market organically as against inorganic means. So most of you would appreciate that a company in the metals and mining industry is a very capital intensive, it's a very capital intensive business. And for you to set up a steel plant or even come up to the commercial production would take possibly 5 to 7 years. For example, we set up our mother plant is Jamshedpur, and many of you would know. We also set up a 3 million ton plant in Kalinganagar, which is in Odisha, and that took us almost 8 years. So you kind of weigh pros and cons of setting up and then going into the market, or if you are able to find a good asset which is fitting your kind of corporate strategy, culture, business operations, and I think then it really is an attractive kind of proposition for us to look at. And each one of the acquisitions that we've done in the recent past have all kind of been with this kind of an intent, because India is one market which is growing very fast. And looking at the Indian market, obviously many international steel players wants to come and kind of put up plants here. So obviously Tata Steel being in business for 100 years, we have that first mover advantage, and I think we've taken that advantage and it's worked out extremely well.
While you're addressing this very important issue of inorganic growth, quite apart from some of the things that you will no doubt talk about and echo some of the things that Vicky said, perhaps we could also just spend a little time and say a few words about some of the regulatory considerations that you might be thinking about when you go into thinking about an M&A situation.
Sure, Jay, if you would have asked ChatGPT this question, they would have said possibly, why do we need, all of you sitting here, the lawyers, if ChatGPT could have answered it, so you would have made all the lawyers sitting here redundant, but I think that's where we all bring in our own expertise and the aspect of nuances that come into while looking at a deal, whether you're looking at it as a strategic investment where you're putting in a certain amount, and what are the reasons that when we look at deals, how do we look at it, what are the aspects, whether it's groundbreaking technology, whether it's, growth, whether it's to do with aspects of unique value propositions that are coming in, or you're giving unique business models that are coming into it. You're looking at strategic investments in that particular way. The other aspects is that sometimes you have to determine why would you go in for an investment, strategic investment, or an M&A versus just doing a commercial deal. And a lot of times as lawyers, we love negotiating our commercial deals and commercial contracts and putting in all the clauses therein. But what are the advantages that we think we will get if we are looking at an M&A or a strategic investment versus, an aspect of typically getting into a commercial agreement? So most of the times, once you have a strategic investment, it becomes easier in terms of, you have the aspects of looking at the growth perspectives of the target company. You get visibility to their growth chart, and your commercial deal can be structured accordingly. Of course, we are all talking all this within the ambit of law and ensuring that we're complying and looking at whether there are antitrust perspectives and other law compliances that are required. But you're also looking at, how we can enhance governance when we're looking at strategic investors as strategic investors within the target company. We're also looking at, sometimes the aspects of deals wherein through a strategic investor, a commercial agreement, termination doesn't become effectively, it becomes longer typically. You can, through the correlation and the aspect of being an investor, go forward and drive the commercial agreement to a longer perspective. Those are the aspects, we look at when we are dealing with strategic investments, including the aspects of, looking at not just the regulatory or licensing deals. You're actually managing to keep technology with you through the licensing deals. So, these are aspects as corporate counsels we have to look at when we're looking at M&As or strategic investments. Of course, there are certain myths around the aspect of, if you're doing a commercial deal versus, if you're a strategic investor, you have access to everything because you're a strategic investor and you have the aspects of business plans, the growth aspects, the growth trajectory, all of those things, including right of first refusal. You sometimes have protective rights that you build in through commercial agreements, which are like protective rights or right of first refusal, or brand visibility or marketing visibility or plans of the target company. But the myths typically are, you cannot drive pricing decisions. Being a commercial, you might have a commercial agreement, but you cannot drive pricing decisions. You cannot be blocking supply chains. You cannot be getting data of competitors through the investment that you're doing it. So these are aspects which you have to consider and then take it forward.
And so your commercial agreements, okay, let's say that you want to introduce a product into a market as a manufacturer, let's keep it simple. And you go through, let's say, a sales agency agreement, then you go into a distributorship agreement where you buy and resell as opposed to an agent. Then you go into licensing perhaps. But so what you're saying in terms is there's a market opportunity. I want to protect my technology because licensing may not get you there. Maybe it's in a market that doesn't protect your IP rights as much as another market may be or that you're used to. So M&A, you start thinking in terms of M&A because then it gets you to all of those opportunities, but you have greater control on the process, right? You have greater control on the process. Of course, the valuation has to be right, okay, naturally. But then there may be other synergies that you might think about when you think about, let's just go the whole hog and not just go step by step. You've taken the initial steps, you've tested the waters in this market, and then because for all these reasons of synergy, expertise, management expertise that maybe the target company has and you need, okay, the technology maybe the target company has or you're giving them technology. For all of these reasons and market expansion, you go into and go to the further step of actually entering into an M&A context, right? So that's very interesting because sometimes as lawyers we only get to see the non-disclosure agreements and the term sheets and the letters of intent. We don't get to see the decisions and the business parameters that are considered before you get to that point. And I think as lawyers, business lawyers, transactional lawyers particularly, even as litigators, you need to understand what the mindset was for the business people before they decided to go in for a more complex strategy than just mere commercial agreements. PK, just very quickly, you talked about, I just wanted to pick up on a case study and Tata Steel's acquisition or merger with Bhushan Steel is an excellent example. PK did mention that. It's one of those examples that has, against that, you can go through all the issues of, let's say, it wasn't a small acquisition. It was about US $8 billion. It was the first IBC process. Okay, it was a public listed target. It was a merger scenario. Yeah. Plus the fact that you had all the issues of timeliness. So just to dwell a few moments on that and some of the challenges that you faced.
Thank you. So yes, this was the first, I think the first big corporate that came through the IBC process, and all of us were on the learning curve. When I say all of us, I think obviously we, people internal to the company, but I think the councils as well. EZB was advising us, P&A law was advising us. I think they were also learning the law as it unfolds. There is theoretical aspect to the law, but there is the practical considerations that you get to know as you go along. I think one thing which we did extremely well is to close the deal very, very quickly. We got the order from NCLT on May 15th, 2018. And on May 18th, 2018, we took control of Bhushan Steel. So just in about 2 days' time, we had lined up the entire management team, the operations team, the new board of directors, all of the corporate policies. The entire framework was implemented on May 18th. So that was very well done, and we just took control of the corporate. And once you get into the corporate, we found that we had some challenging time, because obviously, unlike a private deal where you probably get to do diligence far more deeply and then understand the target far more intricately, here is a company which is coming through the CIRP process. There's only limited information that's available, and beyond that, you really don't know. So you actually commit yourself to kind of, take this asset and then transform without actually knowing what is there once you get in. So obviously there were challenges in terms of business. Obviously it was a insolvent company. Challenges in terms of controls, challenges in terms of ethical processes, because Tata Steel, being a 100-year-old corporation, has a certain way of doing things. So obviously you now find the target not fully in alignment with you. Challenges in terms of safety aspects for a company like Tata Steel, which is in the metals and mining industry. The most important area is safety. So we found a lot of challenges in actually telling people, or at least educating people, as to why safety is so very important. Simple things like, if you are walking up the stairs in Tata Steel, if you aren't holding the rail, you will get a chit from the head HR or the CEO's office. It's as simple as that. Or if you are walking up the stairs and looking at your messages, you will be hauled up. And these are very strict processes. So challenges in terms of safety processes, challenges in the legal areas. Obviously, once we started going deep, we found one, the law wasn't clear whether a successful resolution applicant will be liable or will not be liable for the past acts. So there were regulators who kind of knocked at our doors, both on civil side and on criminal side. SFIO was one agency which was behind us, and of course we then went to the High Court of Delhi, made our submissions to state that we are actually a third party who has bought this asset in good faith, and the past misdeeds can't be attached to the successful resolution applicant. Actually, that paved the way for an amendment in the IBC law in terms of section 31A. So even the government agencies, while they were extremely supportive, they were also actually learning in the process. And of course, we found some challenges on the SEBI regulations front, because there was no clarity on whether you could delist the securities of the corporation. In fact, the delisting amendments came only on May 31st, 2018, whereas we got the asset on May 15, 2018. So obviously, Bhushan Steel was the only company where the shareholders did not lose money because the shares were not delisted, and they actually got the Tata Steel shares when we folded back this company into Tata Steel. Otherwise, post that, every other kind of successful resolution applicant delisted the shares without there being any intrinsic value. So that was a great challenge. Minimum public shareholding was in itself a challenge, because we were putting in some 36,000 crores and we couldn't exceed the 75% threshold because the SEBI law did not allow. Again, that amendment came post the resolution of Bhushan. So we had various challenges like this, but I think it was a great learning for all of us. And to be fair, whether it was SEBI or the Ministry of Finance or the Ministry of Corporate Affairs, they're very open in kind of IBBI. They were very open to take our suggestions, take our representations, and I think they kind of tweaked the law as they kind of went into the future. And of course, the judiciary also did its kind of bit in supporting the IBC law, and you had some fantastic judgments come out from the Supreme Court, which held that the successful resolution applicant cannot be made liable. So I think all in all, whether it's on the policy front, the regulatory front, or from the judiciary, we found a lot of support. And now, when we look back into the 4 years of experience of Bhushan, it's been a wonderful acquisition for us. It's added 5.6 million ton capacity to the company, very seamless integration, and all of the stakeholders, whether it's employees, vendors, customers, they're all very happy because they have become part of Tata Steel.
Thank you, PK. So M&A is a good thing. Okay. I'm just going to shift gear a little bit and throw it open. Ravi and others can come in. You come across this fact that, okay, we're going to do a share deal or we're going to do an asset deal. That's pretty fundamental. Okay, why do we do that? Why do we think about a share deal which is based on a balance sheet? Why do we think about an asset deal which could be, taking over, transfer and taking on going concern, or you cherry pick assets? Okay, why do we do that? Valuations are an issue, tax considerations, of course. So let me just throw it open to everybody here. Why do we do a share deal, which is of course based on a balance sheet valuation, or why we might do an asset deal? Okay, and let me ask Ravi and others to maybe throw some light on that.
Thanks, Jeff. I think the challenge sometimes with asset deals, again, it depends on the sector. While we end up seeing asset deals more often when there are liabilities in a company that people are worried about or don't know enough about. And I think in those cases, asset deals make a lot of sense because you can cherry pick the assets without taking up the liabilities. The challenge with that, however, is at some level valuation becomes challenging. Secondly, creating the whole ecosystem, right? Be it employees and so on and so forth. It's difficult. Most important, again, depending on the sector, you have to take a whole new set of approvals, be it for the site in the factory, be it for employees, and so on and so forth. So other things being equal, if there isn't a huge risk or worry of unknown or undisclosed liabilities, or if there is a huge liability you want to stay out of, I think a share sale transaction is what most clients would prefer in a finance. But of course, if these liabilities are problematic, then an asset sale is something that people definitely consider.
Just to add this, that I think timeline is also another thing. So if I'm in a hurry and I really want to close the deal, then probably a sale would be better because, like you said, there are lots of other approvals that can kick in that are needed to kind of close an asset deal.
I think for financial investors like us, doing a share sale deal makes a lot of sense because we have seen that in case it's an asset deal, the distribution of proceeds becomes a big challenge. In a share sale, you can simply have the proceeds distributed if it is cash. In case it's a share swap, people are happy with that. If they are getting folded up into another bigger corporation. But yeah, that's one more challenge that we normally face in asset deals all across like Southeast Asia, US, India.
And I think what Mike said, or indeed what Vardhan and Ravi said, is all correct because I think that's a global phenomenon. People prefer a stock or rather a share deal as opposed to an asset deal, which has a lot more challenges. There are tax considerations, valuation issues. You don't want to assume liabilities that you correctly pointed out. You want them to retain liabilities. If you have those kinds of issues, then going in for a share deal is so much easier because you're basically, that company remains a subsidiary of yours, if you will, if it's a controlled transaction. Yeah. Okay, so let's just shift gear again and let's just talk to some of our different considerations here. And I'm going to pick on private equity. VC is slightly different, but let's pick on private equity. In terms of private equity doing a control, you can be the single largest controlling shareholder without being a majority. So let's take majority or single largest controlling shareholder and a minority participation from a private equity player. So I'm going to throw it out to, again, you, Vinayak and Ravi, and I'll come to Vardhan slightly later because he's got a little more nuanced approach to it. So Ravi, maybe you can take the control and majority.
Sure, thanks, Jeff. I think, if you look at the M&A environment in India, and if you go back 10 years ago, if there was a hospital or a pharma company up for sale, almost all the bidders 10 years ago would have been strategic players. Today, the environment is very, very different. I think increasingly, financial sponsor clients have gotten comfortable with doing control deals in India, and some of them have had a great experience, right? So I think what we see more and more is financial sponsor private equity clients looking at control deals today, something they weren't doing 10 years ago. And I think part of the reason comes with maybe greater comfort with the regulatory environment. Because I think a huge part of the hesitation is around what are the challenges they face when they're in control of a company? What are the, if I go for IPO, if I'm a promoter, is that something institutionally I'm comfortable with in India? When I'm running a business, am I comfortable with the nuts and bolts, licenses, approvals, local issues that I might face? So I think some of that hesitation has gone away. And I think they're also finding that the Indian business environment has changed. 10, 15 years ago, Indian promoters would rarely want to divest majority stake to a financial investor. I think some of the, and I'm using the term social stigma here loosely, with selling a business is no longer there. It also deals with succession issues for promoters. For the financial sponsor guys, actually, what has also changed is the management pool that is available in India today, that is willing to move away from traditional business roles to, I'm using the term startup or new companies, is also bigger than ever. So if private equity funds want to set up a business today and take control of it, they're also able to hire better talent more easily as long as the talent sees a roadmap, a plan, an exit, an ESOP, and so on and so forth. Lastly, I feel what has worked very well, and I think for financial sponsor clients for us is that once you control a business, of course you control, you take calls on how to run it, how to govern it, how to be acquisitive and when to be acquisitive. But equally, you take control of the most important part of your business, which is exit for a financial sponsor. Once I control the company, I will decide when and how I need to grow it. Looking at my fund life cycle, I can again take a call on when is the right time to exit without having to collaborate with a sponsor who sometimes may have a different perspective. So I think that market in India has really matured because of the culmination of many of these events. And we are seeing, in most bid situations today, you will be shocked. You won't be shocked, but it is very interesting that versus a 5-10 year period horizon, more bidders are actually PE funds than actually strategic players, as was the case maybe a while ago. And maybe let Vinayak and Vardhan, who are much more on the ground experience than I do.
No, that's excellent, because I think you touched upon a couple of issues that we come to once Vinayak and Vardhan have spoken about it, that is exit strategies and how do you actually manage as a financial player. We know how strategics deal with it. Okay, we talked to Coca-Cola and we talked to Tata Steel, but how do you guys deal with it if you're in a majority position? Once you've said, and I think it's relevant here because another thing that you said, and I don't know if the audience picked up, is the succession issue. Since the time I've been practicing law to it is today, you see the difference in the mindset of a promoter who started the company, who's probably in his late 60s, 70s, early 80s, and his children who are going to succeed as the promoter succeed to the promoter's family as chairman or CEOs. They've been out doing their MBAs at Stanford, etc. They have a different perspective on how to do an M&A deal. The promoter, obviously, he's emotionally bound to it. His valuation is very different than what a professional valuation would be, or what his sons or daughters as his successors would see it as. So that's another big difference in India, and Indian corporate history in the last 25 years is replete with those examples, of course. But go ahead, Vinayak, you're going to say something about the minority here.
So all I was saying is maybe to second what Ravi said. The better certainty in regulatory environment, more talent being available in India, and of course the entire India story. You are seeing more and more of these control deals happening. Succession is a real challenge. I saw one of my first deals on those same lines like 10 years back, when one of a big manufacturing plant, the promoter realized that none of my kids want to pursue what I'm doing. Who am I waiting it for? So at the age of 50, he thought I'll hang my hat and now move on to doing something else. So that is leading it. During COVID, one of our partners at Lightspeed tweeted something when all of these stories about countries like companies abroad treating expats differently than the locals. One of our partners had tweeted about come build in India. So during COVID, people saw a huge exodus of people coming in from their plus jobs in countries outside India and then coming to India. So that pool is now available, and therefore you see that people who want to step into be that CEO or CEO of a company, there's a huge number of people now, and that makes PE funds very comfortable of being able to manage companies even without that same person who was in the office for the last 10 years. So I think these two are leading it a lot. I see these deals from a regulatory perspective given the role, and I think India, amongst its peers in the entire region, is shining really bright on in the level of certainty. We hear all this negative news about there were uncertainties, but if you compare it with other countries in the region, I think India is far ahead, and therefore it's also becoming an attraction for everyone.
They would take a minority interest, not necessarily take a majority controlling interest, and they're quite happy doing that.
Yes. So
And you certainly see advantages even if you're taking a minority interest.
yes, we have seen that. We have seen deals are bundled with other players where there is a lead who is taking maybe 30%. You only get 12%, but still you're happy because you have the confidence of being able to make a coalition who can manage the company.
Because in the M&A context today, it's not necessarily that you see a strategic. I mean, you could see a strategic selling to a PE, but more often than not, particularly today, because PE, generally speaking, has a different approach to things. A lot of M&A today is PE buying from another PE. And they could be minority interests, they could be controlling and majority interests, right?
That's correct. You see a lot of those deals. Not as many at Lightspeed, but it's something that's happening in the market quite regularly.
That's interesting. So just since we're on this minority topic, I'm going to switch gear and go to like a single limited partner PE, who also has other responsibilities because you'll have certain fiduciary responsibilities to, let's say, a particular family, etc., family foundation. But so Vardhan, maybe you can mention a few things in terms of the considerations that you have when you think about an M&A.
Before I go there, I just take a step back. So I work both with the early seed stage, growth team, and buyout and fights. So if I go to the growth stage desk and I say, why it will usually be sector specific. So they would be dealing with FinTech or insurtech or some of the new sectors, and they are very excited about minority stakes there. Then I go to the buyout desk, and then I'll be like, hey, but why don't you look at it on minority stakes? And they would be probably looking at manufacturing industry. They'll be like, yeah, I have to work the same amount even if I put 20%, because the CIO will ask me the same question. So why not take 60% if I'm going to put that much time and stake my reputation on it? Because then my upside is more. And like Ravi said, then you control your own destiny, right? I can fire the CEO, I can bring somebody else, I can make massive changes if I like. Not that you want to make changes unless they're necessary, but it's a completely different mindset when you are kind of in control. Also, another thing which I wanted to double click on was market expansion. You used that word. Now, once you are certain that if you are interested in a sector, right, and it could be multiple reasons, it could be high margin, it could be high growth, etc., etc. After that, you decide, do you want to do a merger or do you want to do a primary? In the sense that you do a control and then you expand that. And that depends on macros. So, for instance, if the demand is increasing in the sector at, let's say, 50 CAGR or whatever, if it's a very aggressive demand sector, then you would be more inclined to do primaries, because primaries then are, you de-risk yourself. There are no synergy issues. For instance, I can then control how I grow, my market is continuing to expand, and I expand organically. That would be the first instinct of my commercial team. But let's say it is a high margin sector, but the demand is consistent, linear, growing, but not really, I don't see it going at 20%, let's say. Then I look at inorganic. Then I try and get something, which will give me greater returns. And, but the demand isn't increasing that much. So that's how I make money there. So to answer your question, why control or why minority? It will depend on one, what is the sector, two, what is the macro 5-year projection on that, and three, what is my investment objective. So that is my completely pure play PE advisory piece. The next piece that comes is, of course, like you said, that we are Premji invested. As you would know, there is somebody's name associated with us. So when somebody's name is associated with us as the ops team, we are also functioning as fiduciaries and stewards of that person or that name. And I kind of link ourselves to IFC in some way, but not really IFC in the sense that because sorry, there's echo, so like IFC has a ESG mandate or a certain type of investment ethic. Ours is a little more nimble. Ours is more depends on the risk assessment in a specific investment that we would see, and that quote unquote would be reputation. What is PI associated with? What is Premji associated with? And sometimes we even ask ourselves, though we are not directly associated with Wipro, but like, is this the Wipro way of doing it? And we hold ourselves to that benchmark and expect portfolio companies to also reflect that once we are.
Sure. So that's an interesting thing because you're kind of a hybrid between a strategic and a PE because you could be long-term providers of capital. Okay. So just in the interest of time, I'm going to, because this is very important, you've heard a strategic investor's perspective, you've heard from a single limited partner, family perspective, you've heard from a PE perspective, VC perspective. It also flows into what we would do in terms of diligence and compliance. Compliance and I'll get into corporate governance because we've got about 5 minutes and then I want to have another few minutes for question and answers. But just very quickly, I know you guys think differently because of your background in terms of investment, representing the different entities that you do. In terms of diligence, in terms of compliance, certain things about compliance may be very important to somebody, politically connected person may be important to somebody, may not be so important to somebody else. I know to PEs have become very important, less so perhaps to a strategic, different nuance to you as a singer. Maybe you can just give a few comments on that and then we'll quickly dwell into corporate governance.
So, one of the models that we have kind of picked up on is that we in specific in old industry sectors, especially, we like to partner. We like to build platforms which are like JVs with other strategic investors. So let's say, for instance, we're looking at something in steel. While Tata is not lacking any capital, so maybe they wouldn't be interested, but like maybe get a strategic, deep strategic player and set up a platform with them, where we bring in the kind of financial and ops finesse on the investment side for them, and they bring in the ops expertise about the business, and that kind of marries very well. And we have a couple of these platforms where we bring in the deal finesse, we bring in the sourcing, we bring in the getting the platform ready and acquiring assets. And the ops team, with our ops team as well, of the strategic player, then takes over and runs the business with the objective of eventually growing it and maybe taking it IPO. That's where we see that we are able to also reflect on our and stay true to our compass of investment ethic and returns. I think that's how we find a balance, getting into some sectors which otherwise we wouldn't be that excited about getting into on our own.
is for you guys is strategic investments, UC diligence. Last question. Any comments on that? Because I know yours is slightly different as we look at it for you us. And I know the last, go ahead, so
Yeah, right.
yes, strategics.
So I think what becomes very, very important is the governance piece there, and also when you're driving strategic investments is looking at, sometimes you're also looking at driving in terms of appointment of KMPs and how they actually influence and how they can manage the governance piece, and that becomes important from a strategic perspective. And even if it's listed entity, the other aspects in terms of governance, corporate governance, flow in very, very clearly in terms of compliances and Tata will obviously know how it is to do what is to do with governance. But from our perspective, whether it's listed, unlisted, or driving certain rights and governance pieces, it's very crucial to see that at some point in time, your values have to match. You have to ensure that they are actually governed in the way you would like the piece to be governed. Those become very, very important.
So before I throw it out for questions, I just wanted to ask PK, look, we don't sometimes realize the fiduciary responsibilities and the obligations and the liabilities that people on the board of these companies have. Okay, and that is very, very critical. Okay, and equally critical, you all know what being an independent director means and the liabilities that you take on. But even more critical is some of the responsibilities that people like Sonali and PK, and of course outside counsels like Ravi, and in-house counsels like Vardhan and Vinay take on for these compliance and corporate governance issues. Just a last note on that, and then we'll through the questions.
Thank you, Jay. Governance obviously is becoming extremely important, and those of you who've been following the changes that's coming into the SEBI listing regulations will appreciate that India actually has gone from complete left to a complete right kind of a scenario. Certainly, I think there are three key stakeholders who are expected to really perform extremely well. One is the auditors. The regulators now expect auditors to be absolutely performing their role to the T. It's a really high bar on them. The second is independent directors, because somehow regulators think, or even investors think, that for all the governance problems, the solution is independent directors, which is a myth, but that's the perception. And many times, perception is as important as reality. And the third important stakeholder whose responsibilities has really shot up is the compliance officer or the company secretary. And of course, if you're a general counsel, obviously you ought to know and advise the board and the management on some of these compliances and governance practices. And the way we are kind of seeing things unfold is actually, I would still want to see how things will unfold as we get into the next 6 months to 12 months. For example, if you're going to do a deal and if there's a leak, come 1st October 2023, you're supposed to either confirm, deny, or clarify. Now, if you're a counsel or a company secretary, at what stage would you start thinking about whether to confirm or deny? If you confirm, what happens if the deal doesn't go through? If you deny, what happens if the deal goes through and then you come back and say, yes, this deal did go through? So there's lots of judgments that are involved, and I think it will be nice to see how each one of us will exhibit our judgment, professional judgment, and still be on the right side of the law. Same is for the independent directors. The base threshold is the business judgment rule, but I think India is not far from going the US way, where the regulators would say, either I'll put you on the enhanced scrutiny path or complete fairness. Complete fairness means not just the process, but the transactional terms and conditions have to be fully fair. I think we're seeing that kind of journey, and it's interesting, but challenging.
Okay, thank you very much. Gentlemen, I don't think, ladies and gentlemen, I don't think that we may have time for questions. we can certainly do that on a one-to-one basis over coffee or something. We need to catch up with the rest of the program. So I want you to give a big hand to our wonderful panelists. Really, I can tell you what, there's a huge amount of experience sitting here. So if you catch them, if you drill them, make sure that you absorb everything that they have to say in terms of their experience. Okay, thank you very much.